Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You were asked to come here for what we call an arraignment. What the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are regarding your case. Now, the case that you have here in County Court at Law number 2 is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type offenses, and your misdemeanor cases are normally referred to as your petty offenses. It does not mean that your case is not serious. It's just that it is not as serious as a felony offense. And the difference between the felonies and the misdemeanors is the range of punishment. With felony offenses, you can be sentenced to the state penitentiary. With the misdemeanor offenses, you cannot be sentenced to the state penitentiary. However, you can be sentenced to the county jail. Now, if you have a felony offenses is divided into a couple of categories. You usually have a capital murder, first degree felony, second degree felony, third degree felony, and a state jail felony. If you have a capital murder case, the range of punishment, if you're convicted, is anywhere from life to death. For first degree felony, the range of punishment is from 5 to 99 years to life in the state penitentiary, a fine up to $10,000. For a second degree felony, range of punishment is 2 to 20 years in the state penitentiary, fine up to $10,000. For a third degree felony, range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. Or if you have a state jail felony, which is the lowest felony in Texas, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail, fine up to $10,000. Now, the cases that we handled in this court, as I said earlier, are misdemeanors. Misdemeanors are divided into 3 categories: either be a class A, a class B, or a class C misdemeanor. Now, normally the class C misdemeanors are handled in the Justice of Peace Court or the JP Court or the City Court, which is the municipal court. And the range of punishment for a class C misdemeanor is fine only. You cannot be given any jail time. You could be given a fine for punishment. Now, the highest misdemeanor we have is a class A misdemeanor. The range of punishment for a class A misdemeanor is you could be placed in the Jefferson County Jail for a term of up to 1 year or less, which is 365 days or less. You could be given a fine all the way on up to $4,000 or less. For a class B misdemeanor, the range of punishment is you could be placed in the Jefferson County Jail, sentenced to the Jefferson County Jail for up to 180 days, which is 6 months or less. You could be given a fine up to $2,000 or less. Or you could be given both such fine and confinement, which means you could be given a fine and jail time. And that's for class A or class B as well. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called deferred adjudication or unadjudicated probation. And the other type of probation, which is regular probation, is referred to as adjudicated probation. Now, the difference between the 2 is as follows. With an unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, you would not have a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that we cannot disclose the fact to the general public that you are on deferred adjudicated probation for your offense. Now, if you violate the terms and conditions of your deferred adjudicated probation, the state may file a motion to revoke your probation. If the state file a motion to revoke the probation, you'll be arrested. You'll be entitled to a hearing for the court to determine whether or not you violated your probation. If the court finds that you violated your probation, the court can give you a conviction. And if you get a conviction, then you cannot qualify for non-disclosure and your case will not be dismissed. Now, the regular probation, as I said earlier, regular probation does result in a conviction on your record. However, there's something that is called judicial clemency, whereby the court can set aside the conviction and you will no longer have a conviction on your record. And the way it works is you have to successfully complete the probation. Your probation has to expire, which means there cannot be any more time left on the probation. And the court has to discharge you from probation. And if those three things happen, then the court can allow you to come back in the court to withdraw, which means to take back your plea. And if that happens, then any complaint affidavit or information that has been filed against you will be dismissed. And in essence, you will no longer have a conviction. However, if you get a subsequent conviction or a conviction, another conviction later on, then this case can be brought back up. It could be revived or resurrected and used against you. And if you try to get a license with CPS, they could deny giving you a license, or if you have a license, they could revoke or suspend your license. Now, as a defendant in a criminal case, you have rights. The paperwork that I've handed out states that judge's explanation of rights to defendants without an attorney. The first right that we're going to talk about is your right to have counsel. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of this document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed counsel in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign on the line that's titled defendant, and you will date it today's date, November 9th of 2021. Let me do this. Glenda?
Yes.
Okay, now, ladies and gentlemen, those of you who will be waiving your right to an attorney and representing yourself, you would have to fill out the second page, and the second page states, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 9th day of November of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed to me free of charge. Understanding my rights to have counsel appointed to me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Then, if that's your choice, then you will sign on the line that states defendant, and you will put today's date, November 9th of 2021. Now, ladies and gentlemen, you also have other rights as well. You have a right to have a trial by jury. And what a trial by jury is, you'll have 6 people from Jefferson County who will be selected to sit on your case, and they will decide whether or not you are guilty or innocent. You also have a right to waive or give up that right to have a trial by jury. And by doing so, your case will come before the judge. You will not have a jury. Your case will come before the judge in one of 2 ways. It could come before the judge by way of a trial, and we call that trial a bench trial because it's a trial before the judge only. Or it could come before the judge by way of a plea. Now, what I mean by a plea, if a person enter a plea of guilty or no contest, then guilty means you state in the court that you committed the offense that you've been charged with. No contest means you will be, you are not fighting the charges that have been filed against you. So if your case comes before the judge by you pleading guilty or no contest, then you're coming before the court by way of a plea. Now, you can have 1 or 2 types pleas. You can have an agreed plea bargain agreement. What an agreed plea bargain agreement is when you and the state, which is the district attorney, have agreed to settle your case and y'all have agreed on the punishment. That's called an agreed plea bargain. Now, it also can come before the court by way of what we call an unagreed plea. An unagreed plea means that you and the state have not reached an agreement. However, you still want your case to come before the judge and have the judge to decide what your punishment is going to be. So those are the ways that your case will come before the bench if you waive your right to a jury trial. It can come before by a bench trial or by a plea, either unagreed plea or an agreed plea bargain. Now, you also have a right to have witnesses to come to court and testify in your case. Witnesses sit in that chair over there, we call that the witness stand. They can testify for you or against you. You have a right to ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling witnesses in your case. However, the state will be calling witnesses in your case. Now, you also have a right to, what we call a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. The state can't force you to testify. The government cannot force you to testify. The court can't force you to testify. That's your right that you have. It's called a Fifth Amendment right because in the United States Constitution, it's the Fifth Amendment. And it's in the Fifth Amendment where you have a right against self-incrimination. Now you have a right to waive or give up that right as well. Now by waiving or giving up that right against self-incrimination, then in essence, you're saying that I know I have a right not to testify however I want to testify. And by doing so, you'll be waiving your right against self-incrimination. Now, you also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you, the documents, the videos, witness statements, etc. And so you also have a right to waive or give up that right as well. If you do not want to have access to the evidence that the state has against you, you can waive or give up that right to have access or to have discovery to the evidence that you that the state has against you. Now, as a defendant in a criminal case, I mentioned earlier that you could enter one of three types of pleas. You can enter a plea of not guilty, and by entering a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty, and by entering a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest, which means that you will not be fighting or you will not be contesting the charges that the state has filed against you. Now, everyone here for arraignment, you have been arrested and you're out on bond. Every day that you spent in jail on your case, you can get credit for that time toward your punishment. So for example, let's say you and the state has reached a plea bargain agreement 5 days in jail and you've already served 5 days in jail. That simply means that you will not have to serve any more time in jail because you've already served 5 days in jail, and therefore you will be given credit for time served, the time that you've already served. Now, if they're offering more than the 5 days that you served, then, for example, if they're offering 7 days, you serve 5, that means you have to serve 2 days in jail. Now, if the state is offering you a fine and court costs in your case, every day that you spent in jail, you get credit at $100 per day toward your fine and your court costs. So if you spend 5 days in jail, that's $500. If the state is offering you a fine and court cost of $500, you won't have to pay anything. Why? Because you've already spent 5 days in jail and you're going to get credit of $500 that will go toward your fine and court costs. Now, if you cannot pay the fine and court costs, then the court can do a couple of things. The court can put you on what is called a payment plan to give you time to pay it off. Or if you cannot pay it on a payment plan, then the court can allow you to serve community service for your offense. And what community service is, you'll be working somewhere to pay off your fine and court costs, for example. Now, every day that you spent in jail, you get credit. Well, every hour that you serve on community service, you get credit at $12.50 per hour that will go toward your fine and court costs. And if you work 8 hours of community service, that's $100. So you work 8 hours, $100 will go toward your fine and your court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program through the district attorney's office, through Honorable Judge Bob Wortham's office. And with that program, your offense that you've been charged with is dismissed, and you can get what is called an expunction. You can get it erased, deleted, or wiped off from your criminal record. In order to qualify, you have to have an attorney to assist you to get in the program. 2, it has to be your first offense. You can't have a criminal history. And 3, it cannot be an offense involving resisting arrest or unlawfully carrying a weapon. Now, as I said earlier, once you get in the program, case is dismissed. Once you complete the program, you can get it expunged, erased, deleted, or wiped off from your criminal history. Now, if you are a veteran of any one of the branches of the United States military, District Attorney's Office has a program that is called Veterans Court. With the Veterans Court program, any veteran get into the program, your case is dismissed, you complete it, and it's expunged from your record. It's part of the pretrial diversion program, but it's only available for veterans. Now, this court, County Court of Law number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. With that program, the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And the way it works is it's designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. They commit one crime and then commit another crime. And so to address the issue of recidivism, we have partnerships with agencies and centers that's in our local community. We have a partnership with Spindletop. It's the Spindletop Center. It used to be called Spindletop MHMR. And they are our local mental health agency, and they are here to provide services for individuals who have mental health issues that needs to be addressed. They have individuals in court who will do private interviews with you. They can do a screening or what we call an assessment, and they can develop a treatment plan to address your mental health needs, either outpatient or inpatient services. They also have a program that is called ATAR for individuals who are 21 years old or younger. That's our individuals who have issues with drugs or alcohol. With that program, they can provide an interview, a screening, and they can develop a treatment plan as well, either outpatient or inpatient treatment. Now, for individuals who are all above the age of 21, then you can get with what we call OZAR, and OZAR can do the same thing. They can do an interview, they can do assessment, and they can develop a treatment plan, either outpatient or inpatient. OZAR is our local alcohol and drug counsel in this area. Also, for individuals who do not have a job, or individuals who are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, and the Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. They will provide you training in any one of the areas that you choose, and then they will assist you at getting employment in the area that you are trained in. If you have not graduated from high school and you would like to get your GED, CICE has a program as well that can help you to get your GED. And all of these programs that I have just mentioned are free. They do not cost you anything. Only thing you have to do is have a desire to be in one of those programs to address whatever your needs are, whether or not it's mental health, whether it's not it's drugs or alcohol, whether it's not it's unemployment or better employment, or whether or not it's the lack of education. We believe that there's a cycle, and we can break the cycle. Normally starts off with a person who does not have an education, can't get a job. You don't have a job. It leads to using drugs and alcohol. And once you start using drugs and alcohol, it can lead to you committing a crime. And once you commit a crime, you eventually get caught. And once you get caught, you do time. And then once you do time, at some point, you're going to get out. And then you're going to start that cycle all over. And so in order to break the cycle, we have the CSI program that I started within the first 100 days of taking the bench or taking office. I started this program in March of 2017. And I tell people this all the time: when you come to County Court at Law Number 2, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County, the place in which we live. In County Court at Law Number 2, we do not just arrest the problem, we address the problem. We don't just give time, we take our time. And we try to produce productive people, because we believe that if we produce productive people, for the most part, will not commit crimes because they have too much to lose. And so if you're interested in any one of the programs, just let us know, and we'll be happy to assist you at meeting whatever needs that you have, whether it's mental health, whether it's drug and alcohol, whether it's education, or whether it's employment. Now, we have someone from Spindletop Center who is going to come forward and tell you a little bit about their services. We have Jess with the Spindletop Center. Jess, would you please come forward?
Center, Judge Holmes has graciously allowed me to support this one and talk to y'all and see if y'all have any problems that y'all might want to get help getting addressed that we can assist with. Like you said, we can help with both mental health and substance use. And maybe, you know, it's not just for you, maybe a family member or friends that you can refer us to, we can do that as well. We can talk privately in the back if you want. Everything you say will be confidential, wouldn't get shared past anything from what you want to help with. And we can help you get an intake with us, or if you want to go somewhere else, there's a few other community-based programs as well. We can help getting you with some referrals. Are there any questions for me?
Okay. So, ladies and gentlemen, the paperwork that has been handed out, we're going to pick that up. It's going to take us a few minutes to go through it, and just please sit tight for the bailiffs to come by, pick up that paperwork from you, and then once we pick up the paperwork and do what we need to do with the paperwork, you'll be free to go. Now, the other thing is, if you need to go out into the hallway or go to the restroom, you can do that, but please do not leave the courthouse, because if you leave the courthouse, your bond will be forfeited. If your bond is forfeited, that means that you'll have a warrant out for your arrest. Yes. No, you just have to check the one that, well, I mean, if you want to do that, I mean, you can check, you have to check one box, one of the 5. You can't check 2. All right, thank you. And we'll